The newest member of the Supreme Court taught the court a history lesson yesterday.
The framers themselves adopted the Equal Protection Clause, the 14th Amendment, the 15th Amendment in a race-conscious way, that they were, in fact, trying to ensure that people who had been discriminated against, the freedmen, during the Reconstruction period, were actually brought equal to everyone else in the society. The legislator who introduced that amendment said that, quote, unless the Constitution should restrain them, those states will all, I fear, keep up this discrimination and crush to death the hated freedmen.
Joining us now is Professor Lawrence Tribe, who has taught constitutional law at Harvard Law School for 5 decades. And that full court now includes Justice Ketanji Brown Jackson. What was your impression of her debut on the bench this week?
Well, I was frankly really thrilled. I wasn't surprised because I've known her for years and thought she was really brilliant and articulate and historically sophisticated. But she used the opportunity of the oral argument to conduct what is really a masterclass in the original meaning of the 14th Amendment. You could just see her addressing the conservatives on the court. You want originalism? She read them the original history. The 14th Amendment was not passed in order to make the Constitution colorblind, but to provide a basis for legislative action that would take race into account in order to undo the lingering effects of slavery and racism. The people who wrote it, she explained to both her colleagues and to the nation who was listening, the people who wrote it, she read from the reports, the people who wrote it were in favor of a Freedmen's Bureau that applied not only to former slaves, but to African Americans, to give them an equal opportunity. Rather than just going around the edges the way some of the justices did, and even the U.S. Solicitor General, she went to the absolute heart of the case. And the way these oral arguments are conducted in the modern court, the justices are really talking not so much to the lawyers, but to one another. She staked out her position, made it very powerful, and is going to make it much harder for the court to do what I think is unfortunately predetermined to do, and that is to still cut down even further the effective use of the Voting Rights Act to undo racial gerrymandering without even giving the minorities a full equal chance to be represented. But she is making a record for history and basically teaching the country in the process, making it much harder for the court to pursue its agenda of dismantling the process of desegregating America.
Professor Lawrence Tribe, thank you very much for sharing your expertise with us again tonight. Always appreciate it.
Thanks, Lawrence.
Thank you.